Good evening, Mr. Judge Manoim.
Evening, Acting Chief Justice.
Yes, I apologize that we have kept you waiting for so long.
That's all right, thank you.
Yes, but thank you for availing yourself.
Thank you.
You have availed yourself for a position in the Competition Appeal Court, and I see that you hold BA and LLB, is that right?
Yes, correct.
Which you obtained from the University of Witwatersrand.
Correct.
And the BA in 1980 and the LLB in 1983.
Correct.
And you were later admitted as an attorney.
Correct.
Is that right? And you admitted as an attorney which year?
In 1984.
Yes. And you have been part of the Competition Tribunal, is that right?
Correct, yes.
For how many years?
For 20 years.
Yes. So competition law is your bread and butter.
Yes, it has been for 20 years.
Yeah, you are quite knowledgeable in it.
I've had a lot of exposure to it, put it that way. I should never claim too much expertise.
You're being humble. So you now wish to be appointed to the Competition Appeal Court. Is that correct?
That's correct.
Section 36 of the Competition Act says, among other things, that if you are a judge of the Competition Appeal Court, you must be committed to the purposes and principles set out in Section 2. You know those principles and purposes?
I do.
Are you committed to them?
I certainly am.
Okay, thank you. Judge Victor?
Thank you, Acting Chief Justice. Good evening, Judge Manoim.
Evening, Judge Victor.
I'm just going to ask you three brief questions in the interest of time.
Yes, sure.
On the question of public interest, did you pen the decision in Simba and Pioneer Food Group for the tribunal?
That's the most recent one. No,
Yes.
I was no longer on the tribunal when that came up.
Yes, but now let me ask you on the question of public interest. If the Competition Appeal Court is unhappy with the very constructive arrangements that are put in place, for example, ensuring workers have continued employment, etc., do you think the Competition Appeal Court can interfere with that kind of agreement?
It would have to come to the Competition Appeal Court in some way,
Yes.
which means that a party to the merger or the minister was unhappy with the decision, or no arrangement could have been met. And only then would the Competition Appeal Court be involved. But in practice, what's happened with the public interest is there's usually been a negotiation and
Yes.
a deal done. For instance, there was this recent Burger King merger, and there was quite a lot of controversy about the Commission's decision. But at the end of the day, a deal was done and there was a settlement. And the tribunal, in fact, simply had to decide whether the settlement was adequate and decided it was. And it hasn't come the Competition Appeal Court's way.
Right.
So a lot of those cases will be resolved in that way.
Yes, but it doesn't exclude the jurisdiction of
No,
of
it
an
just needs
if-
a party to bring it to
Right.
who's disaffected.
which
as it
is
were.
not going to be the run-of-the-mill case.
No.
Then just briefly, as you know, in America, there's a lot of litigation, antitrust litigation on Google, Apple, Facebook, and Amazon,
Yes.
the GAFA situation.
Yes.
Now, obviously, there's exploitation, there's a manipulation of, they acquire the emerging startups, their barriers, the winner takes all. What is the situation going to be in South Africa? Is there going to be a time when we look at that anti-competitive situation?
I think there are virtually every jurisdiction in the world has, I call them the platforms, has looked at the platforms and dealt with them in terms of whether there has been an abuse of dominance. And I think the time will come when a case like that will arise in South Africa, and we'll have to deal with them. These cases raise problems because the service is free. So the consumer, in most typical cases of antitrust law, is paying too much, and that's the abuse of dominance. But in these cases, the consumer is not paying anything. So the question is, why is that an abuse of dominance? And so the current thinking of the Federal Trade Commission in the case being brought against Facebook is that it's exploitation of other things like your privacy. In other words, you are paying, you're just not paying in dollars, you're paying in your privacy. And if there was proper competition, there'd be greater protection of the privacy. So that's one of the theories they tried to test in that case. And I think we will start to see these platform cases coming up.
Right, and then my final question to you is, as we know, competition law in Africa is flourishing. And we've got CAMISA, we've got SADC, we've got the East African regional competition, and West Africa. Do you think a time will come when there'll be a supra African competition appeal court?
I think we hope that there will be, because I think the ability of jurisdictions in this country to deal with these supranational firms can only be effective if we've got, in a sense, bulk up and have a supranational regulator. But there's a lot of political work that would need to be done to get that done, and I think that's far away. But I think it should still be the ambition to do that.
Thank you, Justice.
Thank you, Judge Victor. Commissioners, Commissioner Makwanishi.
Commissioner Manoim, Acting CJ.
Oh, I'm sorry.
Thank you.
Thank you.
Good evening, Judge Manoim.
Good evening.
I just want to get a sense from yourself, whether in terms of the Competition Commission, the Competition Tribunal and the appeals, do you think justice has been done to the collusion that happened with the 2010 stadium, the investigation thereof, the fact that no one has been prosecuted? It is collusion, it is not corruption. Do you think there's a need to probably add more teeth so that those big brothers could be prosecuted? Thank you.
I think there are two aspects. I think the Competition Act's administrative system did work well, in the sense that firms were fined. There were also civil settlements with a lot of the firms. I understand that in Cape Town, there's a case going on at the moment where the Cape Town municipality did not settle, as did the other local authorities. So that case is ongoing. It's a damages case. But you're right, what has not worked in our system and is still not working are the criminal sanctions for collusion. Collusion has become a criminal offence, but we've yet to see the light of day of any criminal prosecution. And that's the challenge at the moment. So that's a big issue. I mean, it's been talked about for years. It's about resources in the MPA. It's about priorities. But essentially, the enforcement of competition law and collusion has been the administrative system run by the Commission and then the tribunal, the court.
Thank you, Rajma. Thank you, Acting CJ.
Thank you. For the record, that was Commissioner Moiman. Thank you, Minister.
Thank you, Acting CJ. On the last question that you asked by the leader of the court, Judge Victor, on the African continent kind of umbrella body. Now, with the advent of the Africa Free Trade Agreement, do you think we have to wait for a tragedy of abuse of dominance by some of the big firms that will come from Europe and even within the African continent before we put regulations that will ensure that we don't find ourselves with that kind of abuse of dominance in the continent?
I hate to be pessimistic about it, but I think it's sometimes when you have a bad disaster, you force people to say, why did it go wrong and what can we do about it? So I think that if there is an inability to enforce against one of these big platforms, it may well be that that creates the political impetus to say, well, we need a supranational regulator to take on cases that affect the entire continent as opposed to just one national jurisdiction. If we look at what happened to Australia, Australia got into a fight with Facebook over competition law issues, and Facebook's attitude said, well, we'll just leave Australia. And here is an economy bigger than ours, and they were able to say that. Eventually, there was a deal done, but that is the power of these platforms. And in a sense, on the other side, one needs enough citizens who make use of these services to be able to, as it were, balance it. So I think it's very, very important that we do get that. But as I say, it might need a disaster before we get the political impetus to get that done.
Okay, yeah, my last one relates to excessive pricing and predatory pricing. And I know that before you left the tribunal, you were overturned on the, I think it's the Sasol. The two Sasol matters. I'm not sure if you're involved also in the Media 24 one. What is your view should be the role of the appeals court with regards to excessive pricing matters and predatory matters, particularly in the broader context of the Competition Act to deal with to protect the consumer?
Well, if I can just look at the excessive pricing, I wasn't involved in the Sasol case, but I was involved in the earlier case called ArcelorMittal, and Sasol was a follow-on case. Both cases, the plaintiff failed against the firm accused of charging excessive prices. So the appeal court has set a test in the Mittal case, which was later followed in Sasol, which made it difficult for the commission in Sasol to prove the excessive pricing. What's happened in response is that the legislation has actually been amended to set different tests and different comparisons, because excessive pricing is very, very difficult, certainly very difficult for the plaintiff party, in other words, the complaining party, be it the commission or someone else, to bring a successful case. So to some extent, excessive pricing has now is now, as it were, up for new interpretation. And I hope that perhaps we have it's an easier test than the one formulated thus far by the court. As far as predatory pricing is concerned, the matter, we were overturned as a tribunal by the Competition Appeal Court. It then went to the Constitutional Court, and the court split over jurisdictional issues, with some judges only deciding the jurisdictional issues. Other judges decided the merits, and of those who decided the merits, the majority were, in a sense, upheld the tribunal's approach. But because they were, if you counted, it was a bit of arithmetic over here, if you counted those who said the court had no jurisdiction with those who were against the tribunal approach, the case was effectively dismissed. So it's certainly arguable that perhaps the test that was laid down in the tribunal is still good law. It's a matter of argument about the 4-3 in the court of those who decided the merits. But in any event, there's also been an amendment to the predatory pricing, and that may also be a scope for argument. In other words, with the amendment, has it made that debate academic, because there's now a very specified test for predatory pricing? We decided that case not under the general 8C exclusion and not under the predatory pricing provision as it was then.
Thank you, Judge. Thank you, Acting CJ.
Thank you, Minister. I don't see any other. Oh, Commissioner Mpofu.
Thank you. Good evening, Judge Manoim. Yes, just I'll ask two questions in one, because in the interest of time, and also because you've addressed the first issue, which was one of my bones of contention, which was the criminalization of collusion, which has been addressed to some extent. We'll see if there will be actual prosecutions. The other issue is which is a weakness really of the competition regime, I suppose not just in this country, is that it is meant to be a kind of a self-policing mechanism for capitalism itself, which is based on competition, in theory, not being kept. But we know that that never works.
And one of the weaknesses for me about this, whether that system will really ever work, is because there are internal contradictions. One of which is the penalty regimes, which really don't make sense. And if I give you an example, in the 2010 World Cup scandal, cartel activity there, it amounted to something like 53 billion or something like that. And the penalties were 3 billion. So, I mean, if I was one of those people, then you just factor it into your pricing. So, well, maybe I won't get caught, but if I do, in any event, I'll pay 3 billion. So I'll still make 47 billion. Now I'm exaggerating for effect. How do we deal with that kind of, as I say, internal contradiction? Quite apart from the fact that these are big conglomerates which can afford sometimes to just try and outlawyer the commission.
Well, look, you're quite right. I mean, there's a big concern in competition law generally that firms are so big that no fine, because there's a ceiling to a fine of 10% of your annual turnover, that no fine is a significant deterrent. They will just pay it as a part of doing business. And that, in a sense, is the major argument for having criminalization, because when executives go to jail, they will suddenly be very, very careful about when they're sitting in a room discussing prices. And that's why it's quite important to get that system working and for it to be effective. I mean, there are other proposals about making directors delinquent. I think it's less effective, although it has some effect. But criminalization is very, very important in the sphere of cartels.
Thank you. That's all, DCJ. That's my only question, DCJ. Thank you.
Thank you. There are no further questions. Commissioners who are virtual, are there any questions? There are no questions.
Commissioner Barnard.
Yes, Commissioner Barnard.
Very quickly, good evening, Judge Manoim.
Good evening.
Just in the Media 24 matter that was referred to a little bit earlier, interesting matter where you also deal with dominance and the predatory intent, and then also the interesting concept of cannibalization. But I'd like to ask you, in that matter where it's basically deals with the closing down of publications as a result of a sort of unfair competition angle, what do you think effect does that type of judgment have on press freedom, freedom of press in the country?
Well, it does. I mean, the real concern about predatory pricing generally is that it's the way of the big guy driving the little guy out of the market by dropping his prices so the little guy can't survive. And then once he's gone, raising the prices thereafter. And in the case of Media 24, a very viable, popular local newspaper in Welkom was knocked out of the market for that reason. So it not only affected consumers by getting less choice, it affected advertisers with less mediums to go to, and it affected people's opportunity to get a different viewpoint. So we often look at consumer choice as an aspect of competition law, and that raises what you're saying about freedom, different forms of freedom of expression. So I think it's relevant to it, yes.
Thank you very much, Judge. Thank you, ACJ.
Thank you, Commissioner Barnard. I think we've come to the end of this interview. Thank you very much, Judge Manoim.
Thank you.
For availing yourself. Thank you. You are now excused.
Thank you. Thank you very much, Shakti.
I apologize, we kept you waiting for so long.
No, thank you. That's no problem.
Thank you. Thank you.